Good evening, everybody, and welcome to this event of the Center for Fundamental Rights at the Hertie School in Berlin, or good morning or good day, depending on where you're joining us from in the world. It's a great pleasure to invite you here this evening to an event where we're casting a spotlight on exciting new scholarship, launching a book by one of our colleagues, Dr. Grażyna Baranowska. Her book is entitled The Rights of Families of Disappeared Persons, How Bodies Address the Needs of Families. And it appeared in June 2021. And I think it's testament to it's important that we have two immensely eminent international law scholars here to discuss the work with her. Grażyna joined us quite recently at the Center for Fundamental Rights as a Marie Curie Fellow, where she's continuing her work looking at enforced disappearances. In this instance, in an exciting project called MIRO, where she looks at missing migrants, including through the lens of enforced disappearances, but also looking more widely at that topic through international human rights law. As well as being a postdoctoral fellow here at the Hertie School, she's assistant professor at the Institute of Law Studies at the Polish Academy of Sciences. Our two distinguished commentators who are each going to speak about the book for about 15 minutes, and then Grażyna will respond, are Professor Manfred Nowak. As you may know, Professor Nowak is Secretary General of the Global Campus of Human Rights in Venice, Italy, as well as Professor of International Law and Human Rights at the Vienna University and co-founder of the Vienna Forum for Democracy and Human Rights. He's also put his immense expertise to work in various eminent roles for the UN, including as UN Special Rapporteur on Torture from 2004 to 2010, and noteworthy given today's topic, he has also been a UN expert in charge of the special process on missing persons in the territory of the former Yugoslavia from 1994 to 1997, and was a member of the UN Working Group on Enforced Disappearances. Our second speaker, similarly, Professor Olivier de Frouville, who is professor at the University of Paris 2, Panthéon-Assas, is also a distinguished scholar of international human rights law, and since 2019 has been a member of the UN Committee on Enforced Disappearances. He's also previously served on the UN Human Rights Committee from 2015 to 2018, among many other honors. So as I said, each of our speakers is going to discuss the book for about 15 minutes and then hand it back to the author, Dr. Grażyna Baranowska, for her responses, and then we'll open up the discussion to everybody in the room. While they're speaking, I'd ask everybody to turn their cameras off and mute their microphones. And then when we come to the Q&A, you have a choice. You can either type your questions, and obviously a nice succinct question is very helpful, in the chat, and then we can put it to the speakers and to Grażyna, or you can indicate you can raise your hand in the Zoom and we can call on you to pose any direct questions you have. So without any further ado, Manfred, I'll hand over to you for the first intervention of the evening. Thank you.
Thank you, Catherine, and thank you for inviting me to this launch of the book of Grażyna Baranowska. I'm very honored to have received the book, and I think it's an amazing book because it really gets at the roots. If we speak about enforced disappearances, this is one of the most terrible crimes and human rights violations, and it was traditionally seen as a human rights violation simply of the person who was disappeared or who has been disappeared. Of course, persons who disappear are subjected to the worst human rights violations. Usually, first of all, they are abducted, usually in violation of international law. They are brought to a secret place of detention. They are tortured in order to get information from them, etc. But then, in particular, nobody knows what happens to them. Very often, unfortunately, they are killed. So, of course, people, whether we think about the Latin American dictatorships or we think in so many other countries of the world where people have disappeared, are suffering tremendously. but for a long time, the families of disappeared persons were neglected. And I'm very, very happy that at the end of a long journey, the International Convention on Disappearances has also acknowledged the families as being direct victims. So we have the disappeared persons and the families as victims. And that is the book. The book is about what are the rights of families who might suffer for a very, very long period of time, simply because they do not know. And with so many victims and families that I have been speaking to, it is as long as you don't know for 100% that your whatever, husband, father, mother, son, daughter, wife is dead, as long you keep the hope up. You will not give up, because you feel if I give up the hope, I kind of abandon him or her. So they are always in between hope and despair if they find some kind of information. And if I speak of my experiences in the former Yugoslavia, in Bosnia, Herzegovina in particular, that I got to know so many families who came and said, I mean, all those men who disappeared in Srebrenica, for instance, we know they have all been killed. So we know that. So, but my husband, there, I'm sure he's still alive, because I heard from somebody that he might be in some kind of Aleksinac mines in Serbia, and I heard that from somebody else who saw him, or who saw somebody who heard from, etc. So it is totally irrational, but still it keeps them up in between hope and despair. And it also means that they are suffering so many other human rights violations. The husband might have been the breadwinner in the family. If it's clear that the husband has been killed, then you are a widow, and you might get the widow pension. If you are the wife of a disappeared person, you get nothing, usually. So, and there are so many other consequences. So that's why it is extremely important that we think about the human rights violations of the families. And what I like so much in Grażyna's book is that she really goes through all the different bodies that have been dealing over the years. It starts in the 1970s when the Human Rights Committee received in the Uruguay cases the first complaints about disappearances. And then, of course, the Human Rights Committee has to define what rights have been actually violated. Is it only the right to personal liberty? Because, of course, that we know that people have been deprived of their personal liberty, but very often then also saying the fact that you are incommunicado detained, that you are disappeared, is also a violation of the right to personal integrity, so inhuman treatment, very often also the right to life. So there was no right not to be disappeared. And then also looking, and the Human Rights Committee was the first one that also said, but the families are also victims of Article 7 of the Covenant on Civil and Political Rights, whereas the European Court of Human Rights was at the beginning a little bit more reluctant. And I think you are showing that very well also when you analyze, for instance, Article 2 of the European Convention. At which stage can we say that a disappeared person is a victim of the right, of a violation of the right to life? But later it was also when we drafted the Convention on the Rights of Persons with Disabilities, on the Convention on Disappearances, that we felt it's a composite violation of so many different rights, including also the right to life. The most important right of families is the right to truth. which is again written down also in the United Nations Convention. But what families want to know is what happened. What is the truth? What happened to their loved ones? And very often, although they are hoping they might still be alive, they are kind of relieved if they have 100% 100% proof that their loved ones are no longer alive. And that is very, very difficult. That's why it is also so important to open mass graves and to with DNA and other means of evidence actually establishing that persons have been killed and can be identified as being on the list of disappeared persons. But of course, there are also other ways and means by a presumption of death, for instance, but that is only after quite a long period of time. For instance, in Sri Lanka, we could clarify, I mean now in the UN Working Group on Enforced and Involuntary Disappearances, clarify thousands of cases because we could negotiate with the government and with the associations of families so that they finally accepted to a presumption of death and a declaration of death in response to some kind of economic, social, and cultural rights, so pension rights, for instance, or the right to education of their children, etc. So you go really through all the major cases, and of course, in the European, as the European Court of Human Rights dealt most intensively with disappearance cases in Turkey, but of course also in other countries, including the Russian Federation, etc. How it developed actually its jurisprudence. You also go into the jurisprudence of the Human Rights Committee, but then you also look into the whole situation in the former Yugoslavia. And that is, of course, for me, particularly interesting because, as I said, I have been involved there because I've been appointed to the working group on enforced and involuntary disappearances in 1993. And at that time already we had thousands of cases of disappearances from Croatia and from Bosnia-Herzegovina. But the working group had, and I think still has, this rule that it says we are not dealing with cases of armed conflict. So we are not dealing with the persons, in particular soldiers, missing in combat. That is something for the ICRC. So if it is an armed conflict, in particular an international armed conflict, the working group usually does not take up these cases. But since there were so many cases, the Human Rights Commission at that time then said, let's establish this special process of missing persons. And we called it missing persons in the former Yugoslavia to be broader. It also included soldiers or combatants, but it was both an international and non-international armed conflict. And in 1994, I started this very, very difficult mission, which is called the Special Process on Missing Persons in the former Yugoslavia, which meant to be exercised sur place. So I had to go quite often already during the armed conflict in Bosnia and Herzegovina to the region, but also after the Dayton Peace Agreement, and dealt with many cases, and only very, very few cases could actually be solved in the sense that by prisoner exchange, we could actually identify missing persons as being alive and kind of bringing them back to the families. But in most cases, it was then a question of exchanging dead bodies. And that was a very, from an emotional point of view, extremely difficult also for us, but also in relation to the families. But with that, we also started a process which was at that time extremely difficult, because the UN bodies, for instance, the working group had never done that, to really say, we start a process opening mass graves and identifying the bodies. And in ex-Yugoslavia, it was possible to some extent because we had the protection of NATO and the big international transitional administration, you can say, so the international peace operation in the former Yugoslavia with 60,000 troops, etc. And that led then also to the establishment, it was one of my recommendations, that we need an international commission on missing persons. That it means a body where all the different, as both Serbia, Croatia, and Bosnia-Herzegovina, but at the highest level would be represented, but also other countries, the ICRC, and the international community, the Office of the High Representative, etc. And that commission, International Commission on Missing Persons, is still existing, and is still there are still bodies that are currently still identified, people who have been killed between 1992 and 1995. So it is a very, very long time. What we also know from Argentina or Brazil or from Chile, that it can take decades until finally bodies are exhumed and identified. The other body that you are describing is the Human Rights Chamber for Bosnia and Herzegovina, which was established under the Dayton Peace Agreement, and is was at that time the highest court. We were 14 judges, and we were confronted with many cases of enforced disappearances, but during the time of the armed conflict. So also what you described, the temporal element, they were before, because we only could look at human rights violations after 1995, but of course, enforced disappearances are a continuing human rights violation until the fate is established. And we also went into territory in Bosnia-Herzegovina, which was later taken over also by the European Court of Human Rights, and then later also by the Human Rights Advisory Panel in Kosovo. Also there, the work is going on. I just have been with students last week in Kosovo, where I was told that there are still more than 1,618 80 persons who are missing from the time 1998, 99, so from the time of the armed conflict in Kosovo. So it also shows it's still a highly contentious issue, because the families on both sides, but in particular Albanian families, who are looking for their loved ones and have no clear answer what happened from the side of the Serbs. I see that my time is over. There are so many other interesting findings, of course, on Cyprus and other countries. But what I really feel that you worked out extremely well, how the rights of families are violated and what has been done by different bodies, both treaty bodies like the European Court or the Human Rights Committee, or the Committee on the Convention on Disappearances, but also on special procedures. And that is, of course, primarily the Working Group on Enforced and Involuntary Disappearances, where Olivier can speak much better than I about it, because he has been in more recent times a member of the Working Group, and of course other bodies as well. So I leave it at that. I perhaps as a question only, I would like to ask you how you would actually see the current situation in Kosovo. Whether you see that there now with the new government, would you see that there's a certain a positive outlook in relation to the families who are still looking for their loved ones?
Thank you so much, Manfred. Those were such wonderful comments, drawing together, how your assessment of the book and the important work that Grażyna has done in highlighting the composite human rights violation, as you said, of families, but also drawing on your own experience. And I think in the book as well, it's really striking the way that it really captures that you know, this human rights violation is one that has been addressed by a diversity of bodies, and that human rights law has this multiplicity of institutions that work across. You left Grażyna with a question, but I think we'll leave her to respond to that after we've also heard from Olivier. So Olivier, over to you now. Thank you.
Okay, thank you very much. It's a great pleasure and honor to participate in this discussion with Manfred Nowak around the book of Grażyna Baranowska on the rights of families of disappeared persons. It's really a great pleasure and an honor, and I had a great, immense pleasure of reading the book, which I think is really, really interesting, very rich and very updated on all these issues. I hope you be good. I had to, because of a last-minute technical problem, so I'm connected on the Wi-Fi. It's not always very stable. So if you don't hear me very well, don't hesitate to make signs, and I can repeat or restart again my sentence. I think what strikes me in this invitation and this panel is the fact that there are, in fact, more or less 3 generations of academics working on the same issue, enforced disappearances, present in this panel. The first generation, if I may, Manfred, is you. I will be the second, and Grażyna will be the third, covering a period of more or less 25, 30 years of academic research. And in fact, if we think about it, it's quite unusual in research and in international law in particular. Generally, issues in international law attract the interest of the academics for a certain period of time. If you accept maybe the almost eternal issues that are resurfacing from time to time, like crisis of normativity or crisis of subjectivity, new actors, and all these kind of things. I would not call it fashions, but it's true that there are issues which are closely linked to the spirit of the time. In the 90s, for instance, I think many international lawyers were working on state succession to treaties for obvious reasons at that time. In the 2000s, we were very busy trying to conceptualize the respect for human rights in the context of the fight against terrorism, or human rights in the context of trade agreements, WTO relation with human rights. And then in this beginning of the century, many international lawyers are working on climate change, responsibility of businesses, and all those issues. And academics generally address issues until they find a solution, which is not very often, or at least until the controversies are somehow exhausted. So in a way, all the arguments have been put forward and exchanged, and it's somehow a book that you close and you put it on shelves until the next time. And now what strikes me with this panel is that we have 3 generations of academic on the panel, and we are still discussing intensively some human and legal issues around the crime of enforced disappearances. And it's a fact that Grażyna's book is not a repetition of what was said 10 years ago, or 20 years ago. The law has evolved, and the book is fully accounting for these evolutions. But at the same time, the book also addresses problems that both Manfred and I had to face 10 years ago or 20 years ago. And some of them were, for instance, the subject of heated debate during the drafting of the convention, the International Convention on Enforced Disappearances, which both Manfred and I participated. So in the context of this discussion, I would like to speak about 2 of those issues which were the subject of heated debate in particular during the negotiation of the convention. So between 2003 and 2006, quite a long time ago already, and which are 2 issues which are extensively and I think very relevantly also dealt with in the book. The first is the ratione temporis, the issue of the ratione temporis jurisdiction of bodies in charge of dealing with enforced disappearances. And the second is non-state actors. So on the ratione temporis jurisdiction of tribunals or other bodies in charge of dealing with enforced disappearances, Grażyna describes very well the complexities of the case law of various bodies, and also the frustrations resulting from those complexities by the families, which were faced with all these complex solutions which are elaborated by lawyers. And in particular, if you think about the European Court of Human Rights, or if you think about the Human Rights Committee and the case law, very complex case law, in particular of the European Court, I think is very well detailed and very precisely commented in the book. And it looks like if you read these chapters and these extracts from the book, it looks like the European Court and the Human Rights Committee had a very hard time in trying to devise solutions on these issues of temporal jurisdiction in relation to enforced disappearances. But of course, this is nothing compared to the hard time that the families had in trying or proposing solutions and then getting responses which were sometimes very inconsistent, difficult to understand, with various circumstances, very hard to figure out what's the jurisprudence, and to get some kind of sense of security, of legal security when addressing these issues. And it's somehow it's uncertainty which is added to the unbearable uncertainty of not knowing the truth about the fate or the whereabouts of the loved ones, and which is recognized as torture. This uncertainty, this anxiety, and then plus to this anxiety and this uncertainty, you add this uncertainty related to the law, which is very difficult to understand. So the problem arises in particular with this issue, and Grażyna recalls that if you look at all the bodies which dealt with this issue of ratione temporis jurisdiction, and somehow the most open-minded was the Working Group on Enforced Disappearances, and still is the Working Group on Enforced Disappearances. And it's true that in the 2010s in particular, the Working Group very broadly opened its doors to victims, ratione temporis wise, and I see that here that Ariel Dulitsky was a former chair rapporteur of the working group, could also speak about that, because he participated very actively to this discussion, in particular with relation to Spain. At that time, the working group not only decided to address or to draft general allegations, to accept general allegations relating to the violation of the Declaration on Enforced Disappearances, concerning enforced disappearances that started even before the creation of the United Nations. But it also subsequently accepted to receive individual cases of enforced disappearances, sometimes dating back to the period of the civil war in Spain. So it was a very broad conception of the ratione temporis jurisdiction. There was also a general comment on enforced disappearances as a continuous crime, inviting other bodies competent in the field of enforced disappearances to also have a broad conception of their ratione temporis temporal jurisdiction, taking into account the continuous nature of enforced disappearances as an integrated series of acts. As you very well know, the drafters of the convention were aware of this, and they took this issue into consideration, and they adopted a specific provision, which is Article 35. And now, from that moment, there has been a practice from the entry into force of the convention, there has been a practice of the committee, especially in the context of the review of the reports of Spain and Japan also. And maybe a first question to you, Grażyna, is that I'd be very interested to know your thinking about this practice of the Committee on Enforced Disappearances based on Article 35, and what you think about the position that the committee has taken on this issue, and what you think the position of also the committee should be in relation to the communication procedure, because until now the position has only been taken in relation to the report procedure, but there hasn't been any decision in relation to the individual communication procedure. The second point I would like to address, if I still have a bit of time and I try to be shorter, is the issue of non-state actors and enforced disappearances. And in the book, Grażyna, you start recalling very rightly that originally the definition of enforced disappearances include a state agency element. That is that the series of acts composing enforced disappearances must be either attributable to a state agent or to persons or groups of persons which are acting with the authorization, with the support, or with the acquiescence of the state. And you also very rightly recall that the rationale behind this is that is the idea in particular that the families do not find themselves in the same position. The families which are victims of disappearances by the state or disappearances by, for instance, non-state armed groups, in the sense that they, in a situation where the disappearance is attributed to the state, they find somehow themselves, completely in a helpless situation, because they cannot claim their rights with the state, because the state itself is the author of the enforced disappearances. So that was the situation, I would say, from the classical understanding of enforced disappearances, or the understanding when the notion emerged. But at the same time, you also note in the book very rightly that some changes have taken place in that regard, and you note Article 7 of the International Criminal Court Statute, which contemplates the possibility that enforced disappearance as a crime against humanity could be committed by a non-state actor, namely a political organization. So that's one element of change. You also rightly note the case law of the Human Rights Committee relating to Bosnia-Herzegovina that Manfred mentioned, and the disappearances that were perpetrated by agents of the Republika Srpska, which were non-state agents, basically the army of Republika Srpska. And the committee speaks of enforced disappearances in an extended meaning. And even more recently, careful observers have certainly noticed that the working group on enforced disappearances has started to document cases tantamount to enforced disappearances. That's a quote, which are attributable to non-state actors, which have either control over territory or which are exercising state-like functions, such as the Sana de facto authority in Yemen or the Field Marshal Haftar government in Libya. So I would be very interested, Grażyna, to know your own views with regard to those evolutions. Do you think they are desirable? And in particular, in the view, or according to the perspective that is yours in the book, which is the needs or the rights of the victims. And by the way, maybe to kick off the discussion, what difference would you make between the needs and the rights? That's something I was wondering, starting even reading the title. But that's not so important. And but maybe you want to start responding with this. So thank you very much again, and it's a pleasure to continue the discussion. Thank you.
Yeah, thank you so much, Olivier. Grażyna, you now have three quite substantive questions there, from Manfred, his question about Kosovo, and Olivier's two questions about these very deeply consequential doctrinal questions about ratio temporis and non-state actors. So would you like to address those, and then we'll open up for some more general questions?
Yes, thank you. So thank you very much, everyone, for coming, and Manfred and Olivier for engaging with the work and for being here with me. That really means a lot. So with regards to Kosovo, I haven't been following like the most recent things. The one issue that there is with regards to Kosovo, with many conflicts that are interethnic, is the problem of reciprocity and the issue of ethnic minorities from one or the ethnic parts from one nationality to being disappeared by the other one. And I think that poses a very specific challenge in Kosovo, that of course the state question is played on that, but there are other examples in Europe as well where this issue of two nations where disappearances have been committed by both sides and then trigger the problem which make it even more difficult to solve it with legal issues, because it becomes more and more political and less possible to address it legally. The other two questions are, as Cathryn said, very doctrinal, so I'm very excited about them too. So with regard to ratio temporis, it's at the heart of the book because a lot of the claims to the applications were addressed years after the disappearance happened. So we talked about the Spanish, but also a lot of the Bosnian applications, as Manfred has mentioned before. And with regard to the comedy specific, because that was the question, there is, so I think it's really widely accepted that enforced disappearances are a continuing offense, and there's also other treaty bodies have before accepted in the report talked to states in the reporting procedure, talked to states about disappearances that happened long time ago. So for example, the Human Rights Committee has mentioned enforced disappearances in Spain with regard to Spain. So to me, I'm actually surprised that states are surprised by this position of the Committee on Enforced Disappearances, because it's really in line with what other treaty bodies have done before. And here, especially Japan has been really hesitant with regard to that, but this is really what should have been expected from the committee too. It's really in line with the treaty bodies. So the second thing is with the individual communications, because here there is some common ground, but not entirely. So even the decisions of the Human Rights Committee can be discussed that are not really that clear cut. So it's clear that applications can be submitted with regard to enforced disappearances that happen before the date, but then how long ago? So just last year, the Human Rights Committee ruled inadmissible a Spanish case because of the very long past. But maybe if the application would have been more about the rights of the families, and that would be different. So the thing with the Committee on Enforced Disappearance is that differently to the Covenant, there is this very strict Article 35, which really strictly speaks about enforced disappearances that have been commenced after the entry. So that is really different from what we have in other conventions, and it could influence the perspective of the committee. But I don't think it will. So I think that the other articles in the convention are really strong in protecting the rights of families. So if there would be, for example, something concerning the right of privacy of the data of family members, that could be an application even when the enforced disappearance has been committed before the entry of the of force with regard to the state. So this is my expectation, how I see, but we will see when the first individual complaint arrives at the committee, how the committee will deal with that, because I think kind of the real challenge is that it's 35.1, and the challenge is also how the application will be written, the one concerning the past. And I'm sure it will arrive at the committee. That's the one thing that I'm pretty confident about. With regard to the non-state actors, this is is something that I will be dealing more and more with in my research right now. And well, this is absolutely something that is highly relevant, and the numbers of disappearances committed by non-state actors are rising. So Mexico is an example, and missing migrants are also another examples in other areas of the world. And from the perspective of the rights of families, it's really important to see that there's a different framework for the families when this event is called an enforced disappearance and when it's not. So there's the huge difference, because in one situation the family is a victim of an enforced disappearance, and in another situation the family might be an indirect victim. So this is really like, it's a huge difference. So from a victim-centered perspective, it would be obviously good to see in which situation this could be an enforced disappearance. And there's this one perspective that was put forward also in the paper published by the Geneva Academy a couple of days ago, which calls for a broadening of the concept of enforced disappearances to also undertake those committed by non-state actors. And there are upsides to that solution, I believe, because it would cover more, but there are also downsides to it because it might blur the very notion of enforced disappearance. There are also other possibilities that could be applied, and I would personally be in favor of looking into and deepening the position of acquiescence. So looking exactly what the state has done and has not done with regard to the disappearance committed by the non-state actors. So in the very definition of enforced disappearances, it can be done by a state, or there has to be support or at least acquiescence by the state. So it would need to be seen what exactly is acquiescence, and if we could broaden that, I think that would be the kind of the better way than saying this is enforced disappearance also when it's committed by non-state actors. So depending on what we would see are the responsibilities of the state, I could imagine that if the state is not conducting the search, is not looking for the perpetrators, is not supporting the families, then we could judge that as acquiescence, and then for this enforced disappearance, the state is responsible. So this would be another way to go to kind of find a victim-centered perspective on that aspect. And the downfall of that option a bit is the situation of territories where a non-state actor is actually in power. So this is the situation, for example, in some parts of Ukraine, or in Bosnia, where the Human Rights Committee had clearly stated this is an enforced disappearance. And in those specific situations, I probably would be in favor of calling them enforced disappearances when the non-state actors is actually perceiving all the functions of the state. In those situations, in my opinion, it would make sense to call it an enforced disappearance. And I think I should be finishing with regard to the rights and needs. That was very also at the heart of thinking how I should frame it. And I know this is a bit confusing in the title, and the decision why I made that is that I wanted to start the research looking at needs of families and see whether and under which circumstances they can be seen as rights. And the 4 needs that I identified and assessed in the work, not all of them can really be seen as rights. So we have the right to truth, which clearly is a right. Then we have the right to receive remains, and this depends on the jurisdiction, the right to reparation, and also what I would see as a need of families is for the state to take responsibility for the enforced disappearance, so in the form of an apology or in another form, and this could not be framed as a right under current human rights law. So I see we have a question.
Yeah, so thank you so much, Grażyna. We have this wonderful question from Professor Delitsky. I don't know, Professor Delitsky, if you wanted to put it directly, or Grażyna, you can have a look. It's asking the question about the scope. And so you began to explain there how you started with this conception of needs of families, but he asks about why you haven't considered in the book the right to justice, and noting that that's one of the a focus of the inter-American human rights system. And of course, Professor Delitsky has also written about the Latin American origins and flavor of the international law on enforced disappearances.
So in the inter-American system, which is in very aspects the place to look at, kind of to learn new things about enforced disappearances, the notion of the right to justice has a more prominent, has had a more prominent role than in the European system. And that's probably one of the reasons why I did not include it as a separate right. But I do agree. And when I've talked also to lawyers and looked at literature, that impunity was a central aspect, and I did not include. I explained that a little bit in the part where I talk about why I choose those 4 needs. I did not include the need to prosecute the perpetrators, which is kind of the need to justice, for many reasons. And one, while it is also it has been also raised, and one of the reasons is that I looked at human rights mechanisms that were not set up for this reason. So why the European Court of Human Rights, from all the bodies that I've looked at, has been most prominent of raising that in certain circumstances and with regard to Turkey, perpetrators should be prosecuted. This is really on the margins of the cases that I've looked at.
Thanks, Grażyna. You have another question here from Julia Thrull about Khaled al-Masri, I guess the applicant in the case of al-Masri against Macedonia. So the question asks, is there any hope for him to ever get justice? As far as I know, he has never even gotten an apology from his state of nationality. I'm not sure if that's correct. I assume it is. But...
So the apology, so I guess that's, in this question, there are 2 things that I would like to address. So first is what does we understand under somebody got justice? So if kind of in the inter-American understanding, that would be that the perpetrators were prosecuted, that there was a trial, that something has happened, kind of to look at the circumstances. In this question, this is more the thing of the apology, whether or not there has been an apology. And with regard to apologies, the European system, but not only the European Court of Human Rights, but I see that we have the link that I was going forward to. Thank you, Nicholas. In the European system, the very idea of apology is really much less developed. And while it seems something that would be wished for by many victims, and in particular also victim associations, because I think the issue is also when the enforced disappearances are happening on a massive scale, then it really makes sense for the state to take responsibility and to apologize. But this is really not at the heart of any European mechanism that I have looked at. And it was only kind of the most prominent one was the one set up in Kosovo, which was a human rights advisory panel. And it was the only one that really straightforward said that there should be, not by the state, but by UNMIK, that there should be an apology, a public apology for what has been done. So this is really on the margin of apologizing. And I would not really say that an apology would be considered in the European system, as I looked into it, as really part of the right to justice. And here I think we have another question.
Yeah, I have a question from Professor Başak Çağla, the co-director of the Centre for Fundamental Rights. Başak, would you like to pose it directly?
Hi, yes, I would be very happy to. I hope you can hear me, Grażyna. So I just wanted to extend my warmest congratulations. I haven't read the book, and now I'm getting very itchy and very, very curious as the conversation goes along. So I'm just asking a question from someone who hasn't read the book. So this is kind of where I'm coming from. In the discussion, I mean, one of the things that you frame, and also in the earlier discussions, that this is about, you know, treatment of enforced disappearances in the context of Europe, but of course you're doing this very broad comparative analysis, you know, blending both criminal and also, you know, human rights bodies and so on. So what I want to hear, and we also had a question about the inter-American experiences, could you tell us a little bit more about sort of conflict? So I'm also asking from a comparativist's perspective of the differences, and how could we sort of very clearly say, this is what the law is. For example, you said on apologies or on right to truth or on statute of limitations, there might be some very different views. So how did you sort of deal with these diverging interpretations of various UN committees and perhaps also the European Court of Human Rights and criminal bodies? So I'm just curious about the more comparative and conflicting aspects rather than converging aspects. Thank you.
Thank you. The book was mostly on human rights mechanisms, and I looked also at the at the definitions of the criminal court, kind of from the Rome Statute, and at the ICTY, which was interesting because in a couple of cases, enforced disappearances have been raised, but nobody has been actually prosecuted for fined guilty for doing enforced disappearances. And two most interesting example, kind of when looking at conflicting, that I found are families that have raised in a human rights court that a particular event was an enforced disappearance, and at the criminal court that has been found to be a murder. So kind of it really shows the different perspective that a human rights court that deals with an application of a family that says, well, we do not know what happened to our loved ones, and we do not want you really to say that he died. We want you to recognize kind of our suffering and the suffering of a family member, and from a criminal court that looks at absolutely different things. So the criminal law has been really on the margins of my book, and when I looked at it, I showed where the differences come from. And in my opinion, one of the reasons why really enforced disappearances are not that prominent in practice in criminal law is that at the heart of enforced disappearances is the denial. So there would be less evidence to prove that an enforced disappearance has occurred. So in many places of the book, I show how applicants, lawyers were trying to really substantiate that an enforced disappearance has happened. And this can occur in a human rights court, but a lot of those arguments and the circumstantial evidence would not be enough in a criminal court. So we would have the same situation that could be very different perceived depending on the court. And that's also the same for the definition, which kind of the different perspective on a definition also arises from the fact where does it come from, and what is the goal of this mechanism. So kind of on this margin between human rights and criminal law, then I see that this is really clear cut and it's really easy to show where the difference is. But when comparing courts and judgments, that's much more difficult because the outcomes were very often different. So you would have a perspective, for example, on the right to truth by the Human Rights Committee, which is absolutely different than the perspective on the right to on the right to life. Let's say right to truth. So right to truth is also different, but the perspective on the right to life. So at the Human Rights Committee, as long as the family does not argue that the person has died, then the committee would not find a violation of the right to life. Whereas the European Court of Human Rights has taken an entirely different perspective. So bringing the case to the Human Rights Committee, a family might not know, but it will not find a violation of the right to life as long as the family says, we are hoping that the person comes back. And families are raising that even decades after the person has disappeared. So here, like very closely looking at specific issues, the difference, they occur, but it's really, I don't think that most of the difference come from the treaties. It's really from the interpretation of the treaties. And I think this is even more evident because two bodies that I looked at in the book, they also adjudicate on the basis of the European Convention on Human Rights and still reach different perspectives than the European Court of Human Rights. So to me, kind of from a research perspective, that's really interesting that using exactly the same treaty and also the same case law that was available at the time, the bodies reached different, choose to reach different perspectives on that.
Thank you for that answer, Grażyna. And in all your answers, I mean, your expertise on this topic obviously shines through as it's done in the book, but also the way that you've had to, develop a methodology to study this rights violation across different institutions, which I think is one of the topics that we're very interested in at the Centre for Fundamental Rights, where we look at treaty bodies and courts, and we have experts also on international criminal law and the Latin American system. We have just 3 minutes left, so I just invite either of our experts, Manfred or Olivier, if you have any final comments you'd like to make, or Grażyna, if you have any final words you'd like to wrap up with before I thank everybody.
Perhaps if I only may add on the last question, the conflicts. I think if you compare the Bosnian cases before the more recent ones before the Human Rights Committee and the European Court of Human Rights, that the European Court is kind of accepting that quite much has been done, although much that has been done was done by the international community in Bosnia and Herzegovina, but they kind of accept that, and the Republika Srpska in principle has done nothing or very, very little. But nevertheless, these cases are partly declared inadmissible, whereas the Human Rights Committee in very similar cases is more, in my opinion, better in the sense that they're saying, no, the case has not yet been clarified, and the threshold, actually, what needs to be done by the state is higher than the threshold that the European Court of Human Rights is accepting. And we will see how that will develop in the future, but it's also a question of quite much time has already been, it's now almost 25 to 30 years that this happened, and I can also understand that the European Court of Human Rights at a certain point says, okay, not much more can be done, although that's not the case. I mean, also there, in relation with the question to El Masri, I mean, the way how I mean, again, if you saw what happened in Srebrenica in relation to Srebrenica last July, again, that high-level politicians of Serbia, including the president, are simply not willing to apologize, are not even willing to accept the truth, are not willing to say, yes, there was a genocide. So that is, of course, for the families, this is, for the families very often, simply to recognize, to have an official recognition, yes, there was something very terrible that we did and we apologize, is often more important than criminal justice.
Thank you, Manfred. Olivier, did you want a final comment?
Yes, thank you very much. Well, 2 points maybe. First, thank you very much, Grażyna, for your thoughts about non-state actors in particular. I don't comment on Russian temporis because this is, I guess, this is too sensitive. But what I can speak about the non-state actors issue, because we've started officially within the CEG a process to sort of figure out what is and what would be our interpretation of the relation between Article 2 and Article 3 and the way we understand non-state actors' disappearances, being either disappearances different from enforced disappearances or being enforced disappearances. So we now have a working group. We are aiming at a statement which might be adopted next year or in 2 years. So we'll take our time, but I think we can achieve something. And I note in this context I think your very good suggestions about deepening the notion of acquiescence. I think it's certainly a very good idea, and we will really have to, I think, follow that path too. And the second point is about the definition of enforced disappearances and the ongoing debates. So it's not that I don't want the fourth generation to keep on discussing the same issues, but I'm trying to. I would like, in fact, I mean, you very clearly explained the inconsistencies and the difficulties in the interpretation of enforced disappearances, and I would like somehow the bodies which are in charge to take this issue seriously, because we have a duty towards victims to be clear on the definition, to give some kind of legal security on the consequences and on the obligations of the state. So recently, during a conference in Nuremberg, to competent bodies to try to get to a unified interpretation on the definition of enforced disappearances. And I think that would be a great step forward. I think we'll still, us academics, have a lot to discuss on enforced disappearances. But if we can settle some of the issues, I think that would be fantastic. So thank you again very, very much. I think you're contributing to that process remarkably, and so thank you very much. And I was very, very happy to participate in this discussion again.
Thank you very much, Olivier and Manfred. So Grażyna, a final word before I wrap up.
We're also already over time, so I would just say thank you for everyone to participating and for the comments. Yes, and if you have any questions or comments on the book or on today's discussions, I'm happy to get them per email or reach out to me. I'm really excited to talk about the book, so please come.
Thank you so much, Grażyna, and to our two very, very distinguished speakers. As you can see, there's a 20% discount on the book from our website. So I encourage you all to read it and to engage with it and to continue this very important conversation.